So I have Kimberly Russell here. And Kimberly, talking with you, I am just enamored by how much you know and your passion for everything you do between journalism and legal and AI. I really, really was looking forward to this for the past week. Bated breath, talking to everyone about how I am excited to show how Kimberly is helping fix the world when it comes to AI and it comes to how AI might impact us both positively and negatively. So, Kimberly, thank you for being here.
Well, Michael, thank you so much for having me. I'm excited to talk to you. I've been equally excited to just chat some more because every time that we get on the phone or get on a Zoom, we have the best time and just talking about all the possibilities that are happening right now with law and AI and everything.
Yeah, yeah, and I'm so excited. So why don't we kind of slow it down and talk a little bit at a time? You were talking about environmental impacts with AI and how that might impact both the legal world and just universe in general. Tell me a little bit more about what that is and how AI can actually impact the environment.
Yeah, so we're in a really crazy time right now. AI is such a hot button topic, right? It's the sexy new term that everybody's trying to keep up with, and everybody's exposure to it is a little different, right? Some people have played around a little bit with ChatGPT and tried to make a caricature of themselves that they put on Facebook. That's like, ooh, here's me and my terrible towel, right? Like you can see back here, or whatever that says this is my personality. But then you have other people who are building it and using it and leveraging it for discovery, or they're doing it in ways that are really pushing their firms to the bounds of new management, right? But what we're seeing really is that AI in general is reshaping the entire landscape of the world. We're at a huge moment in technological development in general. And so AI is touching everything, not just from a standpoint of how do you run a law practice, how does somebody Google search something, how do you find goods and services, but you're also seeing it touch the physical world as well. So you're seeing a lot of issues being raised in communities and in states that are more rural where they're trying to place data centers. And it really is a race amongst big tech to who is going to own the most amount of data centers. And who owns the most amount of data centers is who's going to be the winner at the end of the day in the AI arms race. The problem is that these data centers are large, they take up a lot of energy, and they make a lot of noise and light pollution for communities. So you're seeing a lot of opposition in places where you initially saw a lot of embrace, right? I remember when my home state of Mississippi first got an investment in data centers from Amazon. It was a $10 billion investment. The state was so excited. They were like, this is the biggest single investment that we've had in our state's history. But since then, other organizations have been trying to put data centers in place. Since you started the startup of Amazon and everything, you've seen the real impact that has on energy levels, on water, on energy prices. So not just the availability, but what community members around the data center or in the state even are paying for their energy prices. And you're seeing people in those states who saw, oh, that's a $10 billion investment in Mississippi or in Virginia or wherever. And they're saying that is really, there's a lot of risk and harm that comes along in our communities. You're seeing um, plant power or data centers that power up with generators, causing a lot of noise, causing a lot of diesel pollution. And it really is just a race to see what we can do to keep the data centers online because there is such a high demand for this technology as it develops. And so there's this growing pain, if you will, in the AI industry between what you need to actually facilitate the tech versus how do we grow and scale it into this amazing thing that is supposed to make everybody's lives better. So that's where you're really seeing a lot of conflict in the physical reality between what's happening in where they want to put these data centers and where and developing the tech. It's not it's not dissimilar to the explosion that you saw in coal mining factories, right, or in natural gas, where you would have
Hmm.
industries come in and build out, the coal mining industry, and you would have places for them to come in, and you would get the resources and mine the resources from those communities, but it would leave the communities dirty. But there was an excitement because there would be job opportunities. Now with these data centers, you don't even have the job opportunities for the communities. It's just a nuisance, really.
Right. Right. So it's draining the resources. It's making it worse to live in. I can only imagine when you say noise pollution or light pollution, what are we talking here? I mean, is it akin to having a bright light on you, or is it like walk me through just for a moment what the experience would be if you lived within a mile, for instance, of a data center? Like, what does that look like?
So it would depend on the different data centers and the proximity that you live in, but it could look anything from like generators running all night, or you would have some that switch on or switch off. And so now you're not able to get the sleep that you normally would, or it's disturbing
Mm,
animals on your farm. And so you're also looking at power grids being turned on and off, or shortages of power, or people and their electricity bills going up because of the generators being turned on and off, and influx of power and all that different energy usage.
interesting, interesting. So these would be situations where you might be representing individuals and individual homes nearby, and then you're talking about this could use a lot of water you mentioned before too. So if there are situations, and California comes to mind, for instance, but it doesn't have to be just California. So when you use a lot of water reserves, they're not there for potential emergency use. And is that a potential problem? Do you
Right.
foresee
So
or
So let's back up and talk about that, because some people are like, how does tech use water and how does that come into it? And what is all this
sure?
energy that we're talking about, right? So, in order to run these data centers, you have to have a mass amount of not just energy to get the computers up and running, but you also have to have energy to keep them cool, right? Because this tech heats up a lot and generates a lot of energy. And in order to make sure that your data centers are running and that that information is stored correctly, that you don't have a meltdown of servers, because all these are on physical servers that are doing the computing. In order to make sure that everything runs smoothly, you have to have a mass amount of air conditioning going through them, particularly when you're in
Mm,
states like Mississippi where it's very hot in the summer, right? So the water consumption comes in not just if you're looking at alternatives to oil and gas for power, but you're looking at water coming in for the HVAC systems itself. So there are big concerns when you're looking at states that have drought, and that's part of the reason why you're seeing these the investment into data centers being in states like Mississippi and
mm,
Pennsylvania and Virginia and Texas. Although Texas has the energy resource, and so does Pennsylvania, right? Because Pennsylvania has a lot of natural resources. They have the natural gas resource, they have coal, they have oil. Texas also has a lot of oil, but Texas has that issue along with the water drought sometimes, right? So
mm.
they have drought. But that's why you're looking in those specific areas. Out west is appealing because you have the availability of solar energy, but big tech is really not as interested in that because they don't see the renewable energy as reliable as electricity and as oil and gas.
Yeah, and I was reading about this, and it may or may not be relevant, but I kind of feel like Elon Musk, for instance, might be foreseeing some issues in the future with, people like you trying to do the right thing for the small people who need their help, right? So representing individuals who live near these places and have their price hikes and they have the noise and they have the kind of lack of sleep and all these host of different issues. So he's talking about potentially building a data center in space, right? Have it be in orbit, have the idea of the cooling system being native to space, and then have solar energy. And I think that might be a testament to what you're saying in a way. There's there's a lot of potential problems with these data centers coming up, especially in areas like Mississippi, Pennsylvania, Texas, where resources might be very abundant, but then there might be a lot of other issues that impact common folk. And so you're kind of talking about different things. I mean, it would be good.
Well, yeah, I mean, I think that a lot of people who live here on Earth would prefer that the data centers get moved to Mars instead of us getting moved to Mars, right? We would like to protect our beautiful natural resources and our homes and our energy and our way of life here on our beautiful planet as it is right now. But there's a conflict between the tech and the amazing upside that it brings, and then all of the risks that you're looking at, both in environmental impact and then also in all of the ways that there could be a defect in the product, right? And I think that it's
Mm,
really important for us as plaintiffs' attorneys who are looking to protect consumers from what can happen as an adverse risk of all of this innovation, to make sure that we are keeping our thumb on the pulse of what those harms are, because this tech is being deployed faster than regulation can keep up, right? People on Capitol Hill really don't have much of a concept for a lot of what tech is, right? And we've learned
yeah.
that through a lot of congressional hearings over the past decade. Um, but you also have them understanding that this is reshaping every industry. It's reshaping the environment. It's reshaping our entire way of life, how we think, how we work, how we interact with one another. And the tech is being deployed far faster than anybody can come up with laws to regulate it. There's a lot of concern in big tech that because we don't have a unified framework from a federal level of how to regulate AI, whether it's environmental and we're building a data center in a state, or whether it is talking about AI being used to make deep fakes of somebody else to harass someone, right? You have a lack of a federal framework to hold companies accountable, whether you're talking about it in a physical sense or you're talking about it in the actual product itself, right? So there is a big opportunity for plaintiffs' attorneys right now to utilize or get familiar with AI in two ways. So one is to start understanding how AI is going to reshape the possibility of liability. So how
Okay.
do we apply doctrine across it, and what potential harms that could be coming down the pipeline, or harm that's already happening, right? That these companies are already on notice that are happening. So a really great example of this is the deepfake litigation that is already taking place. So a deepfake is an image that is generated of somebody without their consent, but it's a fake image. So and you're seeing this being abused it can be an image, it can be a video, and
Mm.
I could talk about deepfakes all day long, because the implications of that is somebody could generate an image or a video and submit it as evidence, and then that has a whole implication on litigation. But to put litigation and its impact on the law aside, we're talking about defects from a consumer protection, or deepfakes from a consumer protection standpoint. So when you're talking about a deepfake, for instance, with Elon, not to, talk about Elon only in this
No, it's okay.
podcast, but Elon's tech Grok got a lot of publicity recently because people were using Grok because it didn't have any limiting factors on the tech. They were using the product, Grok, to generate images of women and children in sexual situations. So they were generating pornography of people without their consent. So that started, I believe that there has been some litigation that has started around this specific thing. There's also legislation going through Congress right now. It's called the Defiance Act. It's passed unanimously in the Senate, and it is held at desk right now in the House. And they're trying to get the Defiance Act law passed if it passes, what that does is that it puts liability for these deepfake AI generated images, not just on the person who generated the image, but on the platform itself. So if the Defiance Act were to pass, then you would see Grok being held liable for an image that is generated without somebody's consent for $150,000 per image, and then it's up to $250,000 per image if it is proven that it was generated and used to harass somebody, right? So you have law in the works that on a federal basis that is looking to hold these companies accountable, and it all comes down to the foreseeability of the risk, right? These companies are already on notice that their tech is so powerful that it can cause this harm. They already are on notice internally about what's happening. You can see that particularly with Anthropic because they've drafted their own constitution of how to develop responsible AI. So you already have a baseline notice from these manufacturers about what they know their tech is capable of and the harms that are already occurring. And they know way more than we even know, right? Because they're tracking all of this. They know everything that's going into the system. They know every time that you log on to ChatGPT to have a therapy session with Chat and say, you know, am I crazy? And they know what the outputs are and how that's impacting the human race. So they already have the harms that are happening. They see what could happen, and they are deliberately making the choice, particularly in Grok's case. They know the harm that's happening, and they were refusing to throttle their tech because they have the ability to change it. They see the foreseeable harm. They can change what their tech does and does not do, and they make the choice to put safeguards up or to let the tech roll. So that's where plaintiffs' lawyers really have an opportunity to come in and hold companies accountable. But it's a doctrine that still needs to be litigated, and you're seeing firms really take bellwether cases right now to try to get some of this worked out. I think something that's really going to impact this a lot is the trial that's going on right now out of California with the Social Media Victims Law Center that is talking about the social media algorithms. Because the big question here is whether or not product liability applies to these AI companies, because the defense in all of this is that they're a platform, that the person who is using AI or using social media they've generated or created their own content and they're circulating it, and that the liability is all on that person. But the theory behind the social media case out of LA County right now is that there's a defect in the algorithm, right? And so that product liability should apply because the defect the defect wasn't in this person posted it, right? It's that the algorithm put this content repeatedly in front of the plaintiff, right? So if you're not familiar with this case out of LA County, what it is it is a case where no other plaintiffs are representing estates of children who ended their lives because, as they're alleging in the lawsuit, because of the algorithm that put content in front of them that encouraged them to end their own life. There's similar litigation that is happening against OpenAI, where ChatGPT encouraged people to end their own lives as well. These are people who are vulnerable, who big tech knows are vulnerable, and they know that they could throttle the algorithms, they could throttle the tech on on AI, but they're choosing to let it run for the purpose of making money or pushing their tech so that the tech gets better and that they make more money, and that they're at the top of the arms race of all of this, right? So the bellwether case out of LA County and everything that's being litigated with social media and the product liability theory around the algorithm is something that can apply in AI as well. And you also have legislation in the Senate right now that was introduced by Senators Dick Durbin and Josh Hawley. It's called the AI Lead Act, and if that gets passed, then product liability doctrine would apply to AI. So I think what you're
Oh,
seeing across the board is really a watershed moment in big tech about whether or not product liability doctrine is going to apply. And if so, that means that a lane of litigation could open up against AI companies and big tech that would be analogous to, big tobacco, asbestos, opioids, all of that. I mean, it could be the next big MDL. You could be looking at a lot of opportunity to litigate and hold companies accountable. Now, for me, I'm a first generation attorney. I built my law firm all on my own, and I got into law because I wanted to hold people accountable. My parents were journalists. I grew up in a newsroom. I was a journalist before I went to law school. And I'm very passionate. The reason why I got out of journalism and became a lawyer is because I wanted to make the world a difference and not just write about people who are making a difference in the world. And so for me as a plaintiff's attorney, I'm very passionate about changing systems and holding people accountable. It's not just about how do we get an MDL up and running so that we can have a profit at the end of the day. Do we have a business to run? Absolutely. But the opportunity here is really to make sure that consumers are protected from harm while regulations lag behind, right? Because we are in the spot where people in Congress and people in state legislatures don't really know how to handle this, and judges and lawyers don't know how to handle this, and the only people who really know or understand how to handle it are people who know how to use or build the tech themselves. So
yeah.
plaintiffs lawyers have a huge opportunity here to come in and help protect consumers if you jump in and help lead the doctrine that is going to be formed around it, and the only way to do that is to start picking up these cases.
I love that about you. Like the passion and the storytelling. So you started out as a journalist, is what you're saying, right? And then
I
so
did.
that ties into your ability to tell a story. Now you were mentioning a couple times that in some strategies that actually allows you or avails you some opportunity to get news involved. Has
Yeah.
have you thought about that before?
Yeah, so I am somebody who I grew up in a newsroom. I am friends with journalists. I'm not a lawyer who's afraid of journalists at all. They actually still are some of my closest friends, and I think that there's always value in making sure that you're winning both in the court and in the court of public opinion. And you want to do that ethically and responsibly always, but particularly when you are looking at any high stakes litigation and you're looking at that, whether it's from a mass tort or an MDL or a class, or if you're looking at a singular case that is high stakes, you want to make sure that your litigation strategy and narrative are honed in a way that anybody can understand. And that's important,
Mm,
starting from the top when you write your complaint all the way through to when you go to a jury trial, right? Because your jurors need to understand you. It's fine if you can go to the court and you can understand everything, but if you couldn't sit down and talk to a family member who didn't ever go to law school or maybe didn't even graduate high school and explain to them what the theory of your case is, then you're not going to win in front of a jury, right? So something that I am really proud of is my ability to get the press involved, but also to communicate the story in a way that gets press interest. But that also translates to holding a jury's attention, right? Is being able to say, all right, we've taken this really complex thing. You've listened for a week to all of these to these experts. You've listened to all of this stuff, and now I'm going to put it all together for you, and here's all you need to know in order to understand it. Because when you're a journalist, because I was a producer, I wasn't on air. My mom was on air, my dad was a producer and a news director, but I wrote the shows. And so what you learn to do when you produce is you learn to write for a fourth grade reading level. So you learn to take really
yeah.
complex stories and write them down into 20 seconds and write them for your audience at a much more accessible storytelling level. Um, excuse me. So I'm very proud of that skill. It's something that has allowed me to work well in co-counsel relationships across the country. Um, and it's something that I love working with other lawyers to help them understand, whether we're talking about how do you get ready to do an interview, how do you go on a podcast, how do you get press coverage, to what's going to resonate with a jury, or looking at voir dire questions and saying, okay, well, here are the issues of this case. What's going to matter to this juror? And how do we carve out the questions that are best going to say, okay, so this person has this type of background. Here are the claims of this case. This is a question that's going to get an answer of whether or not they're going to help us, right? Understanding the
Mm-hmm.
mindset of who your audience is something that I take great pride in being able to do.
You should. You should be very proud of that. I mean, you have this brilliant mind. You're, creative, and you have all these different intuitions that are usually right on the mark. And so you're in a situation where you can tell that story in a way that everyone can understand. You were explaining so many things just now, like complex ideas with AI environmental impact, AI deepfake impact, and then the social media addiction. I mean, the way you summarized the social media addiction lawsuit just now was better than I have done in probably 20 different videos in a matter of 4 minutes. So, I kudos to you. That's amazing. You're in a situation where you are truly not just a current star, but a rising star in the mass tort world, where I already have law firms. I know I'm going to talk about you for a moment. I already have law firms who are eagerly looking to work with Kimberly, sorry, on future projects like the AI environmental situation, and also on social media addiction. So it's one of those situations that you should be very proud of yourself and what you've established, because you came from a bigger firm. Is that correct?
I did. So I worked with a firm in New York City called Levy Konigsberg, and I've also done some work with a firm out of Dallas called Dino, Mar, Branham, and Shirley. And I was really thrown into the deep end in New York, and I love my pals at Levy. They are great people. I'm still in contact with all of them. And they threw me into the deep end working on the Jackson water crisis, and then also on J&J meso cases. And I've learned a lot of great writing from them, and I got to learn how to manage a big docket, big, important, high stakes dockets, really with no experience. Because before that, I was in Mississippi and I was doing child welfare at a state level. I worked with a Supreme Court justice there, and then I worked with the agency that coordinated all felony child abuse across the state. All that to say, my background in journalism has allowed me to take really complex information from a lot of different spaces, right? And then synthesize it down in a way that's like, here are the issues, and here's what we need to be communicating in order to get this point across. So that's why I've been able to fluctuate. Like, I've been able to move successfully from very different subject matters, from child welfare. One side was neglect, the other side was abuse, and then going into EPA and water with the Jackson water crisis, and then going into asbestos and mesothelioma, and
Mm-hmm.
talking about talc cases there and traditional asbestos, and then now into the AI space. I just see so much parallel in the asbestos and big tobacco product liability manufacturing doctrine, to what's going on with the AI. And I think that we have I think this isn't a matter of if, it's a matter of when. And the attorneys who get involved on the AI litigation up front have a better chance of leading the way and having a seat at the table than the ones who are going to play catch up later on. It just depends on what role you want to play, really, right? When you're talking about
Yeah.
MDLs, do you want to be like the lead counsel and be on plaintiff steering committees, or do you want to be somebody who helps gather the cases and helps push them across the finish line? Everybody has a role to play when we're talking about mass torts. But the opportunity to lead on AI in any capacity, whether you're advising firms, whether you're incorporating it into your own shop. I know that there are a lot of lawyers who are concerned about the ethics of it, because you see all these headlines about sanctions. You saw out of the Southern District of New York where a judge upheld that there was no attorney-client privilege. That's a very careful opinion to read because the judge's opinion was very narrow. It wasn't that, if you interact with AI at all, that attorney-client privilege is waived. It actually was that the defendant themselves opened up Claude or ChatGPT, one of them, before they
Okay.
hired counsel and started to evaluate their case. And the government said that we want that, that's discoverable. And they said, no, that's work product. And the judge said, no, that wasn't at the direction of counsel. That wasn't the counsel who did it themselves. That was the defendant. And the defendant, because they engaged in it of their own and it was a third party, that was discoverable. You also had I think it was the same day, you had a ruling out of the Eastern District of Michigan where where a party tried to get discovery against attorneys themselves, I believe, who were using AI, and they wanted what they were putting into AI. And the court in the Eastern District of Michigan said, no, that's attorney work product, because that's a tool just like Lexis or Clio or anything else. So you don't get that, right? So you're having courts that are grappling with issues, even just like privilege. So when I say that AI is everywhere, you're looking at it from a standpoint of regulations to mass torts to even how you use it in your practice, because it is a seriously powerful tool for drafting, for analyzing discovery, for business operations. Any way that you can grow and build, AI is essential for that. But there's just a lot of moving landscape right now that everybody wants to be, or that everybody needs to be aware of. So for me and for my firm, we're positioning ourselves to advise law firms on how to leverage AI to get a better practice, particularly when you're looking at a mass tort docket. So we co-counsel people on that.
Okay.
But we also are looking to get involved in AI from a litigation standpoint and bringing these cases, whether it's environmental or deepfakes or self-harm or other types. Another thing that's rising is this thing called agentic AI, which is where you build or code out employees, like admin staff, that it will run on its own. It will have its own code and will run its own type of stuff as an employee. But there's major concern based off of liability of who is liable for that. Is the company who hired the agent liable? Is the tech liable? Where up in the chain of the product design is the defect, and who is liable up that chain? So you really have this impacting everyone, because you're also looking at hallucinations in the AI or in the legal field. So that has sanctions. Or you're looking at medical malpractice where you have issues with or errors or in hallucinations in AI. And so typically when you see mass torts, in my mind, they can be pretty isolated to here's your line from like cause to damages all the way through. But AI is more expansive, like a pyramid almost, because you have AI up here, and then the cause and exposure and damages are all different, and they span across so many different fields. There's just there's a lot of things for plaintiffs' attorneys to become aware of for potential cause of actions here.
That's so interesting, because I was looking into some different accountability issues when it came to, I'm not sure if this is similar in a similar vein or not, and you can correct me if I'm wrong, with personal injury lawyers who are concerned about, self-driving vehicles. And if a self-driving vehicle creates some sort of an accident, or was it fault for an accident? Was that the driver's fault? Does it go to the insurance company? Is it a product liability issue, where it kind of goes towards the manufacturer of that system? And a lot of people are of the opinion that it's a shared responsibility and should go to both. I wasn't sure if you had a similar viewpoint when you're talking about AI when it comes to being used as a tool. If OpenAI, for instance, would be potentially liable for therapy, for medical use, for legal use. Like we
Yeah.
covered recently, there was an individual in Chicago who used OpenAI to go pro se and like do all of the pleadings and the motions using AI, and then the insurance company decides to sue OpenAI for the illegal practice of law in Illinois. And so the idea is, regardless of disclaimers and everything, would you still see AI being liable if the manufacturer's liable.
Yeah, and I think that so the autonomous cars is a really good example of the famous phrase "it depends," right? Of like who's liable in all of this. And so to run with the autonomous cars for just a second, car autonomy levels, they vary, right? So you can have anything from like Waymo, where it's entirely self-driving, to where you have lane assist, or you have like a Tesla that you can, set it and forget it type of thing. So your levels of autonomy range, and so your liability is going to range. And I think that that's going to apply with agentic AI as well, right? So if somebody is using it in a way that is puts the liability on them, or is reckless, or is negligent, then you're looking at the comparative fault here versus if somebody was using it responsibly, but the defect is in the product itself, then you're looking at the company itself being held liable. So I think you're going to have a constant analysis across these different points coming up, but it's so important to get familiar with the tech and how the tech works, so that when you're bringing these lawsuits, what you can who you can recover against. It's also important to understand all of that too from a discovery standpoint too, right? Because
Yeah.
like we just talked about, if you are, filing a lawsuit in any mass tort or any tort that you bring, you want to be thinking about in your ESI how to do discovery demands for AI generated results. So if there's like a chat thread about something that's relevant to your case, you need to be writing discovery demands that get that chat thread from the party. So that's all stuff to consider. So that's why it is so important for lawyers. I know that it sounds intimidating to understand, because we always make the joke of like, I went to law school because I didn't do math. You really don't need math to get involved with AI. You just download it and you talk to it like you would a friend on the phone. You just go back and forth. You can hit record or whatever. So if you don't have any exposure to it, it's really easy. But the key thing to have a leg up in this litigation and in understanding this format is understanding the tech. And it is so accessible. It's so accessible. And the one thing that I would want to make sure that law firms understand is that when you start doing this tech, I mean, obviously don't upload sensitive client documents, but the other thing to help safeguard you is to look into enterprise subscriptions where you pay to make sure that everything is online, but always make sure that the training is turned off. So what that means is that when you interact with Chat GPT or you interact with Claude or any of these things, it's taking what you do and using it to train the AI model. So when you go into it, it's training it. It's taking what you've written and training it back onto the model. If you turn that off, everything that you put into it stays local. So you want to make sure that that's a setting that you turn off when you start using all of this, whether you're using it for drafting. And then you want to check and make sure when you sign up for companies like Spellbook, or you have Copilot and your Microsoft, or you have LexisNexis or Westlaw's AI, you want to see about where all of that is living and make sure that you have a policy within your law firm addressing AI. So I guess the point of, or the theme of this podcast is that now is the time to learn about AI and to not be intimidated by it. It's truly not intimidating. It sounds intimidating and sci-fi like, especially if you're an attorney who has trouble converting like a Word document to PDF, but truly it's even easier than that. And it is okay. And if you want to talk about it, feel free to give me a call, because I can talk about AI and how to implement it into practice all day. I can talk about it from a liability standpoint all day, and I can talk about it from a regulatory standpoint all day. It's one of my favorite things to analyze.
I mean, I have you in my back pocket as one of my best friends, where I can call anytime. How can anyone get in touch with you? If they wanted to give you a ring or they wanted to send an email, what's the best way to get in touch with you?
Absolutely. So the best way to get in touch with me is to go to my website. We have a form on there, particularly if you go and look at our page that is for law firms. So if you go to russellatlaw.com, all spelled out, RUSSELLATLAW, russellatlaw.com, and then you go to the tab that says co-counsel, and then click on discuss a case. You can fill out a form and we'll talk to you. I believe we also have contact information at the bottom. Yeah, we have our email address for the info at Russell at Law, and then we have our firm phone number. So feel free or connect with me on LinkedIn. All of that is on our website as well. So happy to get in touch with anybody. But like I said, we love to partner with law firms, both on litigation and doing litigation strategy or executing litigation, to co-counseling on trials, to even just talking about law firm management from a tech perspective. We have people on our team that have built legal tech, and we are all about leveraging it to make our lives easier. In fact, the people that we partnered with on our team, Austin Brittenham and his team out of Washington, we had a discovery deadline in a case that was really, really tight. We had to reformat a mass amount of ESI, and we had 2 weeks to do it. And he wrote a program, and they got it done in a week. So it was in this beautiful format. It was fantastic, and that's the type of tool and I guess skill that we have within our firm, is being able to say, okay, well, what is it that you need and how can we leverage tech really quickly? And so I'm also very passionate about that because as a plaintiff, we are always David versus Goliath, right? No matter the MDL that you're in or how big your firm is, we are always David versus Goliath. And so we are at a point right now where tech is a good equalizer, but it will quickly become tipped one way because larger firms have the resources to build custom tech, and they are going to invest in that. Right now, they're doing it to kind of carve out the menial work and to get the billable hour down, but that gives plaintiffs an opportunity to get caught up, because what that's going to shift to is where they already are papering us to death. It's going to be even more so because they can go on and tell ChatGPT to generate not ChatGPT, but like a spell book or a Harvey or whoever, and say, generate this brief or generate 20 of these types of things. They can just, and that will be done in an hour. Right? They'll have a brief generated for drafts to file and be done in an hour. And so keeping up to date with this is the only way to make sure that you keep up with the arms race of all of this. It's going to reshape litigation. So that's where it's really important to understand the tech and make sure that you keep up to speed with everybody, because you would go expert for expert on everybody, but that's also why you need to go tech for tech with your opponents as well.
That's how you hold Goliath accountable.
Exactly. So you don't want to fall behind on it. You want to make sure that you hold Goliath accountable. And again, right now is the time that it is the great equalizer. It is, and it doesn't take, some of these subscription services cost so much money, but some of them you can build out custom tech or you can bootstrap it for really, really cheap. It's giving solos and small firms a much better chance to come up and really hold Goliath account. Like the real Davids have an opportunity to really hold Goliath accountable right now with the tools that are accessible.
It's phenomenal. I'm being messaged by your team right now saying that you're 1 minute away from your meeting. So I want to thank you, Kimberly, for being on. I have so many great ideas for a future series of conversations in AI. Like, how does a law firm properly use AI? What is AI doing in the environment? That's your lawsuit. What's AI doing in deepfakes? That's representing people who have been impersonated and all these different horrible individual problems. And then there's social media addiction, how AI could potentially be used in different ways to train algorithms to keep people on a platform, and a lot of times irresponsibly, right? And put people in harm's way. And then there's the whole, conversations about disclaimers and if disclaimers hold up. So there's a lot of awesome topics. Did you want to
and
mention anything
also and
beforehand?
also talking about, yeah, something that I would love for us to maybe dive into deep into one of the episodes is to talk about how this is going to impact litigation, particularly from a trial standpoint, right? So when you're talking about how, judges are using AI or responding to the use of AI, how this impacts your evidence, how to spot fake evidence, all of that type of stuff is stuff that we can get into.
Amazing. I'm so excited. I love talking with you, Kimberly, and I think the
Same.
world is going to fall in love with you if they don't haven't met you already. So, thank you so much for being on. I learned a lot, and hopefully you had fun.
I did. I had a blast. I can't believe that I yapped about AI for almost an hour. This was great.
Only an hour. Only an hour. Not almost. It's not a problem at all. I mean, I will speak for most people when I say that there is a lot to cover, and you did a phenomenal job. I mean, that's one of your major abilities, distilling down complex ideas into simple means. So, thank you for being on. I love you as a friend. This is amazing, and we'll see you again soon.
Absolutely. Thanks, Michael. Take care. See you soon.
Thank you.
Bye.